Good afternoon, Mr. Chairman, members of the committee.
Delegate Sullivan, good to see you.
I can feel the momentum in the room.
You definitely haven't been in appropriations across the hallway.
I'll try to make my remarks briefer than they were going to be. I know it's getting late. Members of the committee, Mr. Chairman, there are a lot of Virginians from all walks of life and from all around the Commonwealth who are eager to start or expand their families. But they're unable to do so for a variety of reasons, in the same way that most of us here did. And a lot of those reasons are medical reasons, but others as well. And they have turned to what's called assisted reproductive technology. ART is the term of ART. The Virginia Code has recognized ART for 25 years, first passed the statute in 1994. And what HB 1979 does is updates Virginia's surrogacy law statute. I should stop probably at this point and say there is a substitute, which I think has been, and I'm happy to.
Senator Seward moves, Senator Howe seconds the adoption of substitute. All in favor of adopting a substitute signify by saying aye. Aye. All opposed, substitute is before us.
Thank you, Mr. Chairman.
Now, and Delegate Sullivan, just so we can kind of get to the nub on, and I don't want to interrupt you, and you can go back to your presentation, but the substitute largely addresses some of the concerns about the commoditization of embryos.
Well, I'm not sure it's the commoditization. What happened over in the other body is in the original version of the bill, the word owned was used in several places, or ownership was used in several places.
Treats them more
with respect to the embryo.
Right.
And what I can do
an embryo is more as a human being than as personal property.
Sure. Well, what I explained to my colleagues, both in committee and on the floor, is that, again, in this area of practice, that is, while it's a phrase that kind of hurts your ears and hurts your eyes, it is the way these things are dealt with. I can tell you, for instance.
But are we treating the embryo as a human being or as property?
We are treating the an embryo as something that someone or a couple has control over the use of.
Well, it's either a human being or property.
Well, I'm not sure I agree with that, Mr. Chairman, with all due respect. But for instance, let me tell you, I'm looking at sort of Virginia's most groundbreaking case was decided just a year or so ago by Judge White in Mecklenburg County Circuit Court. This is a case, this is happening with greater frequency around the country, of a couple that had frozen an embryo because what happened was they had a child, and the wife got sick with cancer and was about to undergo a course of chemotherapy and some surgery, and they wanted to have another baby, so they created an embryo, and that embryo was cryogenically frozen. Then, of course, you know where I'm going, they got divorced. And as a part of that divorce, the question became what to do with this embryo. The husband wanted to destroy the embryo. The wife wanted to have another child so that their existing child could have a biological sibling. The court, and this is, again, as I said, it sort of hurts the eyes and ears, the court dealt with this under the equitable distribution portions of the code, awarded the embryo.
And I think that's what some members had some difficulty with.
Correct.
And that's frankly why we come to the legislature sometimes, is because we think that the definition that's been adopted may need to be changed.
So
that the courts are operating without the guidance that the General Assembly is supposed to give.
So returning to your original question, Mr. Chairman, in every case, and there were 8 places in the bill, where some form of the word owned, past tense own, or ownership, wherever that appeared, the substitute before you replaces it with 10 words instead of 1. And those words, I'm looking, for instance, at page 106, excuse me, line 107. Instead of saying the embryo was owned, what it says is the embryo that was used is subject to the legal or contractual authority over the use of the embryo by an intended parent, either because of a court order or a contract of some sort. And in every place that owned or ownership appeared, the substitute describes it in that way rather than using words like ownership. 13th Amendment took care of ownership of human beings a long, long
Senator
time
Stewart.
ago.
Mr. Chairman. Delegate Sullivan,
Yes, sir.
this whole issue of ownership's given me a great deal of uncomfort. And so I've looked at this definition and I have a question. Could we use the word custody instead of authority?
Subject to the legal or contractual custody.
Custody rather than authority?
Mr. Chairman, Senator, I appreciate the effort, and I actually thought of that word, but again, this is all high-tech, and so it's sort of hard to describe. In most cases, in fact, indeed, in every case, the actual custody of the embryo is at a cryogenic facility. The people who created the embryo don't have custody of it. Literal custody is at a facility, an IVF clinic or a cryogenic facility.
Well,
So
but-
they have, that's why I chose the words
But it says-
authority over the use of it, because
Mr. Chairman.
But it says, subject to the legal or contractual authority over the use of the embryo by an intended parent.
correct.
Why can't you substitute custody for authority? Because it still goes to the same thing, but it is a legal term of art that we use already with children versus authority.
I'm worried about the literalness of the word, Senator. Someone else has custody of it.
Well, how about
It is,
this,
it's in another place.
Mr. Chairman?
Senator Edwards.
How about, say, subject to, what line is it on again?
As an
1A.
example, line 107.
Okay. Subject to the, let's see, but the embryo used is subject to the legal or parental custody over the use of the embryo. Because parental custody is a pretty well-defined term.
Mr. Chairman and Senator Edwards, again, when you start to, in this area of the law, when you start to wade into using words like parent, that's sort of what this bill is all about, is describing who the intended
Right.
parents are. And in some cases, the intended parents
Okay.
aren't the biological parents of the embryo.
Okay. Well, I know that, but,
Yeah.
okay.
Right. Go ahead.
Thank you, Mr. Chairman.
It's just like court. We want to get to the
Exactly,
the
you
things
gotta
that,
take the questions as they come.
I always want a judge to tell me what concerns him.
There's not a big secret that since 1979 has become a bit of a flashpoint, Mr. Chairman. It has a few detractors out there. Frankly, I guess naively thought that I might have the support of the Family Foundation on this, because this bill is really about promoting life and about promoting family. But that didn't happen. So let me just tell you a little bit about what the bill doesn't do before I focus, of course, more clearly on what it does do. We've talked about the ownership issue. It also does not promote commodification of human beings or the sale of babies and embryos. It's already illegal in Virginia to do that. The next section in the code, I think it's actually a part of the bill, talks about you can't broker embryos. This is not what this bill is about. Neither does it, the words have been used in opposition to this bill, encourage the creation of babies without parents. Frankly, it's quite the opposite. These people who want to use these embryos are desperate to become parents and to become the parents of the child that this embryo could become. It's not like Senator Serval's bill earlier, where we got wrapped around the axle on the presumption language. Frankly, with all due respect to, I guess, some of the people you're going to hear from today, the bill has been terribly, in my view, mischaracterized as to what it's intended to do. As I think most of the members of the committee know, the bill is inspired by my constituents, Jay Timmons and Rick Olson, who are here, along with their children, CJ, Ellie, and Jacob. That's Jacob in Jay's arms. The bill has come to be known as Jacob's Bill. So I offer them as my exhibits A, B, and C, CJ, Ellie, and Jacob. They're all here today as a result of this art technology. Jay and Rick had all of those children using this technology. As Jay is going to tell you, the two girls are biologically related to one of them, but Jacob was not. He was the product of a donor embryo. And Jay and Rick faced huge legal hurdles to start and then to expand this family, requiring them to leave the state in order to accomplish it. So Jacob's Law is meant to ease this process and simply make it easier for Virginians to create families like Jay and Rick's family. Let me tell you what the bill does do, Mr. Chairman and members of the committee. It gender neutralizes the statute, which is something the Code Commission has been talking about for a long time. It applies to a single adult, just as adoption has. Now, one thing I would say is, we have gender neutralized and updated our adoption statutes to deal with a single parent. The General Assembly's already looked at that over the last 25 years, but the art statute's been sort of left behind. And think about, there's been some concern about the single parent. Think about Mrs. Patel in the case I told you about, right? She was about to be divorced. She was about to become a single parent, yet she wanted to have, through this art technology, she wanted to have a biological child so that her first child could have a sibling. So this would allow Mrs. Patel, in the case I told you about, to use these statutes. The other things the bill does is, under this language, you would no longer need to adopt after this process when a donor embryo is used, which is an incredibly time-consuming and not to mention expensive process. And it clarifies that only a traditional, that is a biological surrogate, can void the contract and actually keep the child at the end of the process. So those very specific things are what it does. It does not inject any new technology into Virginia's statute. It does not create a new way to have children other than what is already allowed in Virginia. But what it does do is allow more Virginia people, citizens, to have the kind of families that Rick and Jay have. Rick and Jay's family is a miracle of modern technology. And it's a miracle of the power of love. Now, these are children, the products of surrogacy contracts are children that will never have to worry that they weren't really wanted, right? Or that have to ask their parents, gee, was I an accident? These families and the parents in these families go through incredible expense and incredible feats of love to do this. So this, one of the accusations about this bill, Mr. Chairman, is that this is a public policy that creates a devastating public policy. Those are the words that are used, a devastating public policy. It seems to me that it's quite the contrary, that what this does is create a public policy of which we can all be very proud.
And I haven't heard that, and maybe it's in some written materials.
It is,
and I don't
yes,
think
sir.
that you will find people on this committee who feel that. I think that a lot of us share some of your goals, would like to do something, unfortunately, we don't have a Senate companion, so this is something that came to us really late in the process, and we haven't had as much time to cogitate, review, and work over this bill as some others. What I would like to do is, first of all, I don't know whether any member has any questions of the patron, but I know that there are people here who came who would like to speak in favor of the bill, and some who would like to speak in opposition of the bill. And you
Mr.
point
Chair.
out that it is a bill that has generated very strong emotional feelings on both sides. And I want to say that we are going to apply a time clock because we don't have much time.
I understand.
And it's not out of any lack of respect to the people who are impacted by this bill. And we'd love to hear from people who support the bill first.
Mr. Chair,
Senator Peterson.
before we get to the witnesses, I just want to be 100% clear, and I think you're saying that the couples, it would be a married couple or an unmarried individual.
Well, what I was suggesting, Mr. Senator Peterson, I use the example of the unmarried, the divorced mother in the Patel v. Patel case.
Right.
She was about to become a single mother. She won that case. The judge awarded, it was Judge White, awarded the embryo to Ms. Patel.
Right.
Because she wanted to have the child. And assuming she didn't quickly remarry, she would be a single parent, and she would be able to use this statute. And the statute does.
But it doesn't change the presumption of the married couple. that
It does
we have.
not.
That's
It does
all I
not.
had. Okay.
All right. Let's hear from those who would like to speak in favor of the bill. And we're going to put a 5-minute time clock on supporters and in opposition. But before I start the clock, I'd just say your first witness is a good friend to many of us up here. Jay, it's good to see you.
Thank you, Mr. Chairman, and good afternoon to members of the committee. I am Jay Timmons, and I'm the President and CEO of the National Association of Manufacturers. But I'm not here in that capacity. Instead, I'm here as a father in support of Jacob's Law, HB 1979. My husband, Rick Olson, is here. Our children, who you've already heard about, Catherine, Elizabeth, Jacob, we call them CJ, Ellie, and Jacob. All three of those children were born from surrogacy. Some of you know, and the chairman indicated that we know each other. Some of you know me from my days as Chief of Staff for Governor George Allen when we worked together. Former Delegate Clement and I were just reminiscing about my hearings back then. They were hopefully a little bit more pleasant than today. But Governor Allen, by the way, did ask me to relate to you that he supports this bill as well.
I think most of us have gotten phone calls from him.
I know. So our two daughters are biologically related to one of us. We were granted our parental rights through a pre-birth order in California. We believed our family was complete, but quite frankly, God had other plans for us. In 2013, a husband and wife couple with 4 children of their own approached us about expanding our family because they had decided their family was complete and all of their children were produced through ART as well because she was unable to conceive. Because we shared similar views on when life begins, they asked us to accept 2 embryos that had been frozen for over 13 years. They didn't want to risk that their embryos might eventually be destroyed. Our transfer to our gestational surrogate in Wisconsin resulted in a singleton, Jacob, who was due in mid-August of 2015. And as we did in California, we petitioned the circuit court for our parental rights, and we were assigned a hearing in late June. We appeared in person. Judge Sarah O'Brien conducted an evidentiary hearing, awarded us interim parental rights. And we simply needed to inform the court when the child was born. She was a reserve judge. A permanent judge was appointed, and in a nutshell, that judge, Judge Troupas, immediately moved to invalidate the O'Brien ruling, imposed a guardian ad litem on us, and questioned the validity of the state Supreme Court decision that validated the parental rights transfer and challenged whether there was a legal pathway for us to be Jacob's parents in an uncontested parental rights petition. So instead of a 24-hour ministerial action by the court to obtain parental rights that we were already granted by another judge, we endured over a year of legal chaos, fighting with a judge and a guardian who were clearly trying to score political and policy points instead of applying the law and adhering to a well-established judicial precedent. There were objections, motions, deadlines, and delays, a stream of lawyers, unnerving, endless, sleepless nights, continual nausea so acute that we could barely eat just to manage all of the legal issues. Rick had to leave his job of 16 years at Capital One while I tried to focus on doing mine. Weeks of gut-wrenching agony turned into months until Judge Troupas finally issued his decree. He declared, after Judge O'Brien had declared us to be Jacob's rightful parents, Judge Troupas officially took those rights away. He also illegally terminated the surrogate's parental rights. He left Jacob deliberately an orphan and a ward of the state. And then he branded us human traffickers, Mr. Chairman. A third judge finally vacated Troupas's vile ruling and restored the original O'Brien order after Troupas resigned in disgrace. But it was a year of emotional abuse, and it had taken a toll. Declining health from never-ending stress, second and third mortgages to pay the legal bills of 13 lawyers, 2 of which the judge ordered us to pay even though he was trying to take away our child. The constant fear of losing Jacob and having to somehow tell his big sisters. This bill doesn't solve every issue, to be sure, but it's a simple update of a statute that really should not be that contentious or controversial, and it frankly doesn't need to be amended to make it something that it's not. Let me quickly address a couple of the points that have been raised. The bill creates a presumption for parenthood not tied to biology. Well, that's exactly what traditional adoption is. And to those opponents who have made it crystal clear that voting against this bill, they're also saying that adoption isn't appropriate either, when they apparently believe 5,000 kids in Virginia's foster system aren't worthy of a loving forever home. Opponents complain that single parents would be recognized, and that's true. There's nearly 500,000 children in Virginia being raised by single parents today. You've likely seen some other insulting rhetoric going around. But here's the bottom line. We are a real family. This happened to us. The embryo that was Jacob would not have been rescued by us and would have been destroyed or used as scientific research if the opponents had their way. We're very passionate about this because it happened to our family.
Thank you, Jay. We'll register your support, too. Step right up.
Good afternoon.
And I'm sorry, but if you want to identify yourself and register your support or opposition, we'd be happy to hear that.
I'm Julie Stillo. I'm here on behalf of the Virginia Family Law Coalition. We are in support of this bill. Most of you, I think, have spoken with Colleen Quinn, who is a highly regarded ART attorney here in the Richmond area. She apologizes for not being here, and so I have come in her place.
Right.
For the reasons that Delegate Sullivan has expressed and that Jay has expressed, we support the bill. In addition, Colleen would have expressed her concerns about leaving our statute the way it is, having unconstitutionality issues under recent U.S. Supreme Court decisions of Obergefell and Pavon versus Smith. So we support the bill.
Thank you.
Thank you, Mr. Chairman. Briefly, Sam Tao, Deputy Attorney General for Civil Litigation. Just wanted to inform the panel that this will solve the nonconformity issue and the potential liability in 20-158 that we discussed with a previous Senate bill. Thank you very
You all
much for your time.
support it?
Yes, sir.
All right, thank you. Those who'd like to speak in opposition to the bill.
Mr. Chairman, Senators, I am Olivia Gans Turner, President of the Virginia Society of Human Life. This amendment has many, many, many problems and obviously has caused a great deal of confusion and consternation among many of us for a lot of good reasons. Virginia Society of Human Life is concerned about going forward with this amendment, but we are mostly concerned with the reality that the existing law already creates within it a very dangerous scenario where contracts are being formed with couples creating these embryonic children, and those children under those contracts very often could be killed or destroyed either during the embryonic stage or later in pregnancy through pregnancy reduction. We have proffered to you all an amendment that might be possible as not just a remedy to this amendment, which has many, many flaws and is disturbing, but to the law itself in Virginia, and it's long past due. It's something that perhaps is a first step in the right direction, but overall we are displeased with the amendment because it doesn't address any of those concerns and raises many, many others. Thank you so much for your attention.
Thank you very much. Yes, sir.
Mr. Chairman, committee members, my name is Josh Hetzler with the Family Foundation. This says there's come to be a lot of attention on this bill, and for good reasons. It represents nothing short of a
Hey,
seismic
Josh,
shift.
first of all, the substitute that was introduced, I mean, that addresses your personal property issue, doesn't it?
I believe it does.
Okay, so it's better than it was when it came over here, in your view.
Yes, we believe that portion is better than it was.
Okay, so can you tell us, hone in on what your specific objections are, if you would?
Sure, there's a couple of things that this bill does. The bill would sever the biological connection between the child and his or her parents for the first time ever. We believe this is very significant because it would replace the legal basis for parenthood to be a mere contract between willing adults. And we believe that ultimately could undermine all parental rights. For the first time, this bill, a child could be intentionally and permanently deprived of either a mother or a father. We think that's very significant. And we all know how important a mother and a father is in an individual's life. We have concerns about single.
Well, and you and I talked about this, but, you know, aren't we weighing protection of life against your concern about the significance of a mother and father?
We think, well,
I mean, isn't that what you're asking us to do is?
No, Senator. I think we all agree that life, all life matters and should have the opportunity to develop. We disagree that this is the way to do it, because what we think this will do, and what we feel certain this will do, is only incentivize people to go and create more and more and more lab-created human beings There's a reason why we have between 600,000 and 1.2 million of these snowflake babies, so-called. And it's because incentives have been created through public policy to do so. And we believe that this would open up a number of new bases to make more and more and more of those.
Senator Stewart.
Josh, one of the first things you said kind of struck me and helped me with this. You said that for the first time, we would cut that bond between biological parents. Haven't we already done that with adopted children?
The difference.
And don't we try to find homes for children that need to be adopted?
Mr. Chairman, Senator Stewart, I think it's a good question. And I would say there's a big difference between what we're doing with adoption and what we're doing here. And the difference is, the situation with adoption, you're dealing with a broken situation. And we're using the best tools that we have to try to address that. But here, we're dealing with someone who hasn't even been conceived yet, or now is conceived but hasn't been born. And we're talking about allowing people to create human beings in a lab such that we would intentionally deprive them from the very beginning of those parents. But that isn't the way it
But
happens with
aren't we
adoption.
also talking about children who've already been created and finding homes for them?
Yes, Mr. Chairman, and there are ways under our current law, though it is imperfect, and perhaps we can make it easier. This bill goes pretty far, but those have to be dealt with. But we're very concerned that this will not, this will only proliferate that tenfold. And so the adoption process.
Senator Stewart.
Josh, if this bill reports out of here today and off the Senate floor, maybe with an amendment, will you work with these folks to try to see if there's a way your concerns could be alleviated? Or are you just absolutely opposed to the bill? I guess that's my question.
Mr. Chairman, Senator Stewart, we will work with anyone to consider anything that we think will promote families and give children a mother and a father. But we are concerned that this way, you're essentially guaranteeing that some people will be intentionally deprived of that and will go through the entirety of their lives never having had a father, never having had a mother. And that really should concern us all, I think. But we will certainly work with anyone we can, if possible. I see there's a minute, and I want to give my friend in the Catholic Conference an opportunity.
Yeah, thank you. And let me just say, we've interrupted you. I tried to stop the clock to do it, and like I mentioned to the patron, and it's like court. I would like to think that you'd appreciate us getting to the nub of it rather than letting you address things that may not be significant to members of the panel. So, go right ahead.
Mr. Chairman, members, my name is Tom Antorcha. I'm with the Virginia Catholic Conference, and we oppose this bill. As Josh mentioned, we have at least 620,000 embryos already frozen and now stored in the United States. We share the concern that these embryos not be destroyed, but in our view, this bill only heightens that concern. And by extending surrogacy to allow its use by unmarried individuals without regard to genetics, this bill would create even more demand for the creation of new embryos. You've heard that discussed. Lastly, I would just add that if this bill is enacted, even in the substitute form, this would make Virginia's surrogacy law more expansive than that of Massachusetts and nearly as expansive as California in terms of allowing just about any non-genetic arrangement. In Massachusetts, the father of the intended couple must be biologically related to the child. So we believe that children in the embryonic stage of development are not property.
All right, Senator Norman.
Sure.
My question is very similar to what Senator Stewart asked a moment ago, and I'll try not to be more pointed than his gentlemanly behavior. I appreciate that your organization is not embracing this concept with great affection, but if this bill is reported out of here, do I have your assurance that you and your organization will work in good faith to try to find a common ground on it?
Well, Mr. Chairman and Senator Norman, I would have to defer to our board and our executive director for a decision on that. I don't have the authority to make
I
that
would
decision here
really
and now.
encourage you to
Let me-
express your personal view, because, you know, if this report's out of here and y'all aren't willing, you ain't going to be at the table.
And I fully understand the tenor of what both.
And
yours
Mr. Chairman, I
are
would
saying.
say, I respect how your organization works, but, sir, you're the guy in front of me right now.
Yes, sir.
And I can tell you, I'm just one little pissant in this process, but I'd be highly annoyed if those who are opposed to it did not work in good faith if it goes to conference to try to find an acceptable solution. And that's just me.
And if I may speak to the adoption point, sir, is the difference between adoption and this is that in adoption, we have developed case law under
Mr.
family
Chairman, I
law.
told you earlier today, I have done thousands of adoptions, and I've done thousands of adoptions through the Catholic Home Bureau in Hampton and Newport News. So I get that part really, really well.
If I may just finish, Mr. Norman.
Finish real quick.
Senator, just that family law is where adoption belongs. This proposal puts it in contract law. Family law protects the best interests of children, and we just want to ensure that the best interests of children are maintained. Thank you.
No, I appreciate it, and thank you for answering some tough and pointed questions. We appreciate it.
Thank you, Mr. Chairman.
Senator Stewart.
Thank you, Mr. Chairman. The issue for me here is just that these little lives should have a chance to live, and I don't know any other way to look at it. I have some concerns about the language, and I think this is a friendly amendment.
At least it's intended that way.
It's intended to be friendly, and if you don't think it's friendly, tell me. But the sentence that says, but the embryo was used is subject to the legal or contractual authority over the use of the embryo, I would move that we scratch authority over the use.
Where are you?
It would be at everywhere that's used.
For example,
Which are
line
multiple places.
line 107.
Yeah, we used 107 as an example. So I would strike authority over the use, and I would put the word custody in there, and then I would ask Kristen to define contractual custody in the bill when you are able to do that. So I guess that would be conceptual. But then it would read, embryo that was used is subject to the legal or contractual custody of the embryo by an intended parent. And I offer that because I look at this as a life, and I think we should address it as a life and not the way it was addressed, and I hope you look at that as a friendly amendment.
Senator Norman.
I second it.
All right, that motion has been made and seconded. You have any comment on it before we vote?
Mr. Chairman, just briefly, I can feel the train running. I do take it as a friendly amendment. I don't want that to be taken as my agreement yet that it's the perfect way to do it, but we are headed to
We
conference.
understand that.
Or at least potentially headed to conference.
I understand that.
So if we can together come up with something that works for everyone, I'm happy to have that conversation.
All right, the motion has been made and seconded. Kristen, you have it well enough in concept?
I think so, Mr. Chairman. Thank you.
All right. All in favor of that amendment signify by saying aye. Aye. All opposed? All right, that amendment is adopted. Anybody else have any questions of the patron?
Mr. Chairman, I'd move to report as amended.
Second.
I think Senator Peake had,
Oh, I'm sorry. I apologize. I'm happy to withdraw that motion. Okay, if he doesn't have a question?
Kristen, I think that there was one other amendment. No, we've adopted that. Did you have another amendment dealing with? Here. Kristen, is that drawn to the substitute?
this is the one I was looking for, Mr. Chairman. At line 290,
Senator Peak.
288, insert F. Any clause or provision contained in a surrogacy contract requiring abortion or selective reduction is void and unenforceable.
You make that motion?
I make that motion.
That amendment has been made and
What
seconded.
line again?
Can you report that, Kristen?
Mr. Chairman, 290 of the substitute, you would add a new subsection F.
Can you report it so that,
Yes, sir, Mr. Chairman. Subsection F, any clause or provision contained in a surrogacy contract requiring abortion or selective reduction is void and unenforceable.
Now, Mr. Chair, could the proponent of the amendment explain to me exactly what this is about? I mean,
Mr. Chairman.
Senator Peak?
Yes, Senator Deeds, this is a very difficult issue. I think a lot of people have a lot of sympathy for what they are going through. This is a very difficult issue for a lot of us who are pro-life conservatives, and this, for me to have any chance of voting for this bill, is going to have this kind of language.
Mr. Chair, I understand.
Senator Deeds?
I guess I understand that. I just wonder why in the world the issue of abortion would even come up when you're talking about a surrogacy pregnancy. I mean,
Mr. Chairman.
Well,
Mr.
maybe it
Chairman?
won't be a problem then. Senator Peak?
Senator Deeds, in a lot of these embryonic situations, they don't do it as much anymore. They used to put in more, and then a doctor would recommend selective reduction to the mother. And that is something that we have a concern about. And we don't want it to be included in the contract that they can do it. But if y'all have, anyway, thank you, Mr. Chair.
All right, that motion has been made and seconded to adopt that amendment. Any further discussion? All in favor of that amendment signify by saying aye. Aye. All opposed?
No.
All right, let's open the roll.
Aye 7, no 7.
All right, that amendment fails. The bill is before us.
Move report. Second.
It's been moved and seconded that the bill be reported.
Ayes 9, no 6.
Delegate, congratulations, and
Thank you, Mr. Chairman,
this
members of the committee.
this is a hard bill that a lot of us really struggled over, and I just want to thank you for the thoughtful approach that you brought to the bill, and I appreciate your
I want to thank you,
efforts.
Mr. Chairman, and the members of the committee. I've spoken with a number of you, and I will be good to my word. I will speak, as we head towards conference, if we get that far. I'm happy to be as creative as we can be.
If we get to conference, we will certainly work with you.
Thank you, Mr. Chairman.
All right. Next, we have delegate point.